We are back on Morningline. Thanks for joining us, all you viewers out there. And we're taking phone calls this morning for our guest, elder care attorney Tim Takis. Free legal advice if you have questions and the like. There he is, coming from his home office, joining us by Zoom, the one and only Timothy Takis, Esquire the First. Good morning, sir.
Good morning.
Attired
Welcome, everybody.
in the traditional bow tie, as always, looking very dapper. Thank you for joining us.
Thank you.
Hey, listen, we've got some folks that waited through the break. Let's take some calls for you, Tim, and we'll start off with Paul. Good morning, Paul.
Yes, so.
Hi, go ahead.
People getting power of attorney, but then taking all the person's money and fleeing the country. I happen to be a disabled person who lives independently. I rent an apartment. I rent a storage unit. But in the old days, I used to end up in the hospital for a while or jail for a while, come out and find out my property was gone, my car was gone because it had been declared abandoned and auctioned off. So the question is, could I have a power of attorney with someone, but without relinquishing the authority to act in my own stead, to do things for myself, which in the past I wasn't been able to do? It caused me to be chronic homeless for 2.5 years. Therefore, if I go to the hospital or jail again, someone would rent my storage unit, someone would pay my apartment, so when I come out, my property would not be gone.
Okay, Tim. That's a tough one, and I feel sorry for him there, yeah.
Yeah, it sounds like what Paul sounds like, and maybe I've got this wrong, but it sounds like what Paul did is he trusted somebody, and that person that either betrayed his trust, perhaps.
Right.
And certainly it's important for him to have a power of attorney because, as you know, Nick, I've always said that's probably the most important document an adult should have executed. Basically, what you would be doing is you're naming somebody, you're entrusting somebody to handle your legal, financial, and personal care affairs. That's really what you're doing.
Right.
And obviously the most important thing is to find the person that you can trust. Just because you're married does not mean that person is automatically, has that authority. Sometimes our clients think that, well, my wife can pay my bills or my husband can pay my bills or whatever because we're married. And I said, well, there's a lot of people that are going through a divorce right now that probably wish that think that that's probably not a good idea.
Right.
So that's why you can't assume that if you have a spouse that person can do that. Now, in Paul's case, what he should be thinking about, in addition to, okay, who's the right person? Who should he name? Should he limit the authority that he's giving that person? Because it is a legal document, and he can always say, well, you can do these things for me, but you can't do these things for me. Now, sometimes that may be good or that may not be good, but that is one option that he has, is to say, well, you can do these activities for me, but you can't do these other things. Another thing that he could do is he could say, well, I'm going to name someone to be my power of attorney, or we call it an attorney in fact, but I'm going to limit that person's authority to be able to act on my behalf if I become disabled or incapacitated. Now, sometimes that sounds like a good idea because you're going, well, I don't need this because, unless or until I become disabled or incapacitated. But sometimes that can be difficult because you have to put in something in the document that says, well, you've got to get a letter from a doctor, or a primary care physician, and some people would say, well, if you don't see a doctor, can you actually get a letter like that? All those sorts of things. It creates hurdles that maybe you don't really want to impose, on the person that you're naming. Because obviously the most important thing to us, is doing this type of work, is you want to make sure that you name somebody that knows you, that cares about you, and is looking out after your best interest. You know, and if you don't find that person, if you can't find that person, you know, then maybe you could also try to name somebody, a professional, to do that, although that can be more difficult to do, to find somebody. But that's the key thing. Is it's kind of like we talked about earlier on the top of the show, Nick, is, you know, if you've got a trustee, the pet owner wants to name somebody that he wants to entrust his or her animals with.
Sure.
That's really what you're doing, and it's the same sort of thing here.
Yep, and you're right. Getting a power of an attorney, and it's not a difficult thing to line up. And there's the two types. Let's be clear: financial and medical. I mean, I don't know if you can have them all wrapped in one or if they're separate. They're self-explanatory. Financial means you're giving someone else the ability to do some of your financial affairs, all right? And medical means that those people could be in the case. And that doesn't mean they override what you're doing. And really, power of attorney is there.
That's right.
For when maybe you're maybe unconscious in the hospital in some situation and they need a decision to be made, and well, you have medical power of attorney, right, Tim?
Exactly, and probably one of the best definitions I've ever heard was about how it works is that basically it's like having you've got a car and you've got two sets of car keys.
Yeah.
So you get one set to your attorney in fact. You know, and then you keep another set for yourself. But at any time, you can go to your attorney in fact and say, "I want the keys back." You know, and they're supposed to, and they're required to give them the keys back.
Gotcha.
Now, the alternative to a power of attorney, if you don't have one, is that a court would be named would name a conservator for you. Conservator is basically somebody that basically makes those decisions for you. You know, and sort of the way that works is that basically what the court does is takes your car keys away from you. That's what that is. That's what a conservatorship is.
Yeah, and I know from past experience that's kind of a last resort. You're not a big fan of those unless truly someone is completely helpless and not able to make any good decisions on their own, right?
Absolutely. I mean, it's a very useful function. You know, and the conservatorships are. There have been many changes to the conservatorship law over the last 20 or so years. That they're limited basically to what you need. So if you need a little bit of help, maybe with your finances, it doesn't mean that you lose all of your rights. But ultimately, it's as you said, it's not difficult to arrange to get the powers of attorney in place. You just have to find the right people, and get it done.
Gotcha. Let's take another call for you. This one, Tim, from Mark. Good morning, Mark. Are you there?
Yes, sir. I'm here.
Hey, go ahead. What's the question?
My question, my wife of 52 years passed away last Thursday.
Oh, I'm sorry.
Thank you. She was one of these folks who would never talk about living wills, actual wills, powers of attorney, any of that stuff. I, on the other hand, have a will, and I've, done all the other stuff. I had that in place. The fact that we did share everything, there was nothing I kept from her and nothing she kept from me. Is there anything in particular that me not insisting that she make a will, is there going to be anything come up that I probably will have a problem with?
Okay, just wondering.
Yeah, Mark, what happened?
I don't know if many people have that problem where one of the spouses has got a will and one doesn't. But the only thing she had really in her name with me a beneficiary was her IRA, and it's not a very big one. Probably just about $15,000, something like that.
Okay, and they were married for more than 50 years, right, Tim? So I mean, everything, whatever it is, that IRA and everything else, will or not, goes to him, doesn't it?
Well, what happens is that in the case of his wife not having a will, anything that was held jointly by them or owned by them as husband and wife would automatically go to Mark.
Okay. So
if there was a house, the house, if they owned a house jointly, that automatically the title to that house goes to him. You don't have to do anything, Mark, to make that happen. Now, Your wife's IRA, you have to file a, even that's $15,000 IRA, you are the beneficiary, and so you would contact the company, and say my wife passed away, and then the company will tell you that, okay, well, you're the beneficiary, and then you would have an opportunity either to roll it over into an IRA, into, like, maybe if you have an IRA, you can roll that over into your own IRA, or you can just keep it the way it is. So, that'd be like an inherited IRA. Hopefully, when she passed, the funeral home notified Social Security. Mm-hmm. So if her Social Security benefit was larger than yours, then you would get the larger amount. Otherwise, you would get but regardless, there will be a $255 death benefit.
Yeah, we have to remind folks that is still there. That's been around for years, and there is that death benefit most of the time. Nursing homes,
Absolutely.
or rather funeral homes, know about that. I'm curious, Tim, and I don't know that this was this gentleman's situation, but let's just say, as he said, they shared everything, and you just made that very clear what happens. But let's say maybe at one point, for whatever reason, they went out to buy a car, and he has one, she has one, and let's just say that car, for whatever reason, was just titled in her name alone. Okay, and yet everything else is together, but just for whatever reason, the title's just her name. Does he have to do anything special along those lines?
Well, one of the things that, since she did not have a will, then when she passed away, anything that was titled in her name individually, then some of that would go to Mark, and then the rest of it would go to their children in equal shares.
Oh, okay.
So let's say if they had 3 children, then Mark gets a share of that, and then the children get the other 3 shares. Now, as a practical matter, Mark might say, well, look, I don't want that car anyway. I'll just give it to the children. But that's basically how that works.
Okay. Okay, and
we've had cases like that where we've thought the family has thought that they had everything. We had one case I remember, we had husband and wife, where we represented them for 2 or 3 years, and the husband had Alzheimer's disease, and so we thought we had everything figured out. When he died, the family found like maybe an $80,000 retirement plan that was just in his name. Mm-hmm. So we actually had to go to probate court to get that over, to make so that it could go to the spouse.
Right. So you never know if something new comes up. But I think as we go to the break, Tim, your answer to Mark here was that if they did share everything, there's not a lot really he needs to do other than maybe just double checking with the company that has the IRA that his wife left him as the beneficiary. And maybe look into Social Security. I don't know if maybe she was drawing more.
Yeah.
Beyond those things, if everything else was pretty much shared, there's nothing else really he has to do proactively after the fact, is there?
Probably not. Yeah. Mostly what happens is that once Social Security gets notified, typically then Medicare gets notified. Yeah. So the Medicare will stop, those sorts of things. And it's some things that he just needs to keep an eye on if something comes in.
Gotcha. We hope that helps, Mark. And again, I'm sorry for your loss. Listen,
that's so hard.
Tim, let's take a quick break. When we come back, we've got Pat and some others on the horn waiting with questions for you. So got a good show going here. We'll be back with more. And if you want to join us, the number's there on the screen, 737-7587. Back right after this.
This is a